Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, Oregon, I got some updates for you. Now, listen, I am shooting this video at 5:30 in the evening, and it'll probably be a couple more hours before I get it edited and get out, so I apologize for the tardiness of my video. I learned about all of this information this morning. I have not been able to get in front of a camera until now. That's what happens when you're trying to run a law practice because, quite frankly, YouTube doesn't pay the bills right now. Now, listen, as we know, there was some big happenings going on today in the state of Oregon. This is in addition to yesterday's developments where the Attorney General basically threw in the towel on this licensing requirement. So we're going to get all of you up to speed as best we can about what the current events are. So let's spend a few very important minutes this evening and talk about some good news and some bad news out of Oregon on ballot measure 114. Okay, so the issue we're talking about today now is a bunch more developments out of Oregon on this ballot measure 114. I got to tell you folks down in Oregon, boy, I tell you, when you decide to strip people of their constitutional rights, you really come up with a doozy because this thing is moving fast and furious, and I have a feeling that we'll probably do another dozen videos on this between now and the end of the year. However, I want to talk to all of you about two really important cases. One of them is really bad news. The other one, however, is really good news. Okay, so we're going to be talking about Oregon Firearms Federation v. Brown. Now, that is the case that was filed in the United States District Court on the federal level. There was arguments taken on Friday in Portland, and there was a ruling today on the temporary injunction. We'll talk about that in just a moment. We also need to talk about another very important case called Arnold v. Brown, a challenge to ballot measure 114. This is filed under state constitutional grounds in state circuit court, specifically in Harney County. So we're going to talk about both of those cases today. Let's start with some good news, then we'll do some bad news, and we'll wrap it up with some good news. The good news is from yesterday, which is that despite the fact that just last Friday, the Assistant Attorney General thought, hey, no problem, the state of Oregon will have this licensing regiment all ready to go by December 8th. Apparently over the weekend, that Assistant Attorney General talked to just about every law enforcement officer in the state of Oregon who all said, what the hell are you talking about? We don't have any clue how to even get this running. So at the current time, the Attorney General of the state of Oregon and the plaintiffs in that case have agreed to a 30-day stay. That means that no licensing requirement is going into effect on December 8th. That's good news for the folks of Oregon. Now, it did not stay any of the other portions of ballot measure 114. That was going to require that the court grant a temporary injunction. Well, today, hot off the presses, we got the ruling, a 43-page ruling, which denies the temporary injunction in this case. And I'm not going to spend all night going through this ruling here, but I will tell you folks right now that the language that the judge chose to use is very problematic. There was case law that was ignored, but I will give the judge credit. It's a very well-authored opinion, and it provides a huge roadmap for how those in the gun control community are going to try to work their way around Bruin. Now, does it stand constitutional scrutiny? No, it does not. Does case law support it? No, it does not. However, is it a legitimate, plausible, intelligent argument that they're making? Well, perhaps not intelligent, but does it present itself as a plausible argument? It most certainly does. Much better than other arguments I've seen that are trying to basically water down the meanings of Bruin. Bottom line is this. The court has ruled the following. Number one, plaintiffs fail to demonstrate magazines capable of accepting more than 10 rounds are necessary to use firearms for self-defense. So what the court is essentially saying is, hey, listen, you did not even prove that this was necessary to self-defense, thus infringing upon Second Amendment rights. Now, the court made other findings as well, including 2, plaintiffs fail to demonstrate that magazines capable of accepting more than 10 rounds are firearms in common use for lawful purposes. Now, this particular finding I take great exception to, and I think there's very clear case law to the contrary of that, but that is the finding of this court, which is essentially that magazines in of themselves do not constitute firearms, which would fall under the purview of the protection of the Second Amendment. Now, I know what you guys are saying. Well, what good is my firearm if I don't have a magazine? That is true. That's the common sense argument, but please, common sense has no place in gun control arguments. The court made further findings, including 1, that the defendant's evidence that large capacity magazine implicate a dramatic change in firearms technology and unprecedented societal concerns. Now, this is a finding in favor of the defendants here, the state of Oregon, and this is one of the most alarming things, because what the judge is saying here is, hey, listen, the Second Amendment was written way back in the late 1700s, and there's new technology and advancements in technology and firearms, ballistics, and all of these things, and this was never contemplated by the drafters. Now, that despite the fact that there are 2 very clear Supreme Court holdings, one called Heller, one called Bruin, which says that, listen, the Second Amendment protects the types of firearms that are in common use at the current time for lawful purposes, including self-defense. Now, the court made several other findings, including that the plaintiffs could not prove irreparable harm, and most discouragingly, that they are not likely to prevail on the merits. So the motion for a temporary injunction in the matter of Oregon Firearms Federation v. Brown has been denied. There will be no injunctive relief other than the 30-day stay agreed upon by the parties on the licensing requirements. That's all the bad news, and I recognize there is a lot of bad news. You guys need some good news. God knows you in Oregon need some good news. Well, I'm happy to give you some, and that's hot off the presses. It's the case of Arnold v. Brown. Now, Arnold v. Brown, Joseph Arnold, and several other plaintiffs, including the Gun Owners of America and the Gun Owners Foundation, have filed this suit in the Circuit Court of Harney County, Oregon, right down here in the southeast corner of Oregon. I'm sure it's a wonderful place. Well, I'll tell you what, I don't know if it's a wonderful place or not, but I do like their judge, because there was an argument that was made that this law, Ballot Measure 114, violates the Oregon State Constitution, which guarantees the right to keep and bear arms. Specifically, Article 1, Section 27 of the Oregon State Constitution. Now, here's what happened. The Honorable Robert Riccio, presiding judge on this matter, has in fact granted a temporary injunction for all of Ballot Measure 114. That's important. For all of Ballot Measure 114, there is a temporary injunction which has been granted that is effective at 12:01 in the morning on December 8th. So the minute the law goes into effect, so does the injunction. This affects everybody in the state of Oregon. So this is really, really encouraging news. Now, he has set a show cause hearing for December 13th of 2022. What is a show cause hearing? He's basically telling the state, hey, you need to come to court and you need to demonstrate, you need to show me cause why I should not extend this temporary injunction beyond the hearing date. And if the state cannot meet its burden, then the temporary injunction, which is in effect, will remain in place. Now, I understand that these jurisdictions during a lot of the COVID restrictions and stuff would routinely grant injunctions like this, and the state of Oregon would immediately run to the Oregon State Supreme Court to get these flipped. And if the Oregon State Supreme Court is anything like the Washington State Supreme Court, that may happen. So that may be topic of another video. So you may get another good news, bad news, good news video again from Oregon. And it may be when the case of Arnold v. Brown is taken up on an emergency writ or something like that to the Oregon State Supreme Court. So let's get you all up to speed, so you guys, because I know you guys' heads are spinning here. So what does this all mean? The licensing requirement is not going into effect on December 8th. The Attorney General has agreed, shockingly, that no law enforcement agency has any clue how they're going to get that up, okay? The temporary injunction for the remainder of Ballot Measure 114, however, is not going to be granted by the federal court. They have denied that motion. However, Circuit Court in Harney County, in the matter of Arnold v. Brown, has in fact granted a temporary injunction set to start 12:01 in the morning on December 8th, which would stop the implementation of every single aspect of Ballot Measure 114. Now, obviously, we got a hearing coming up this on December 13th, and we got a lot of other things that are happening. This is going to happen fast and furious. You guys are probably going to get a few more of these videos late at night, slapped together, so I can get you all down in Oregon on up to speed on what's happening with your Second Amendment rights. Listen, in the meantime, if any of you have any questions, you can always contact us at WashingtonGunLaw.com, or of course you can call us directly at 425-765-0487. Now, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.